Good afternoon, everyone. Welcome to another episode of Spilling Tea. I am your host, Tiffany Daniels. Please excuse the hair. It was rainy. I went out grocery shopping. And unfortunately, there's not much I can do with it today. Not the point, but yeah. It's driving me nuts. Anyway, folks, first of all, to everybody on Twitter so far today who've wished me congratulations, thank you. For those who haven't heard, some good news. Finally, I was able to go ahead and land the Wayfair work from home position, which I am quite excited about. Very happy and looking forward to not having to constantly use the bus. But anyways, we are moving on today to the seventh and final part of the JRC on trial 2012. Now, I'm going to try to do this with minimal interruptions, but I can't promise anything. So let's go ahead and get to it. I will include the link to this article in the description box, as well as a link to the petition to close down the center. Please go ahead and sign it. After we complete the seventh part, I will go ahead and give you the info as to why this is relevant now, in spite of the ban that they passed through the FDA as of March of last year, 2020. So without further ado, here we go, guys. Allergies. They'll kill you. Okay. The medical malpractice case over the use of electric shock and residence on Andre McCollins at the Judge Rutenberg Center in 2002 went to the jury on Monday, the 23rd of April. Even without any further witness testimony, however, the jury was only able to deliberate for 30 minutes, as the rest of the day was taken up by remainder of the defense's case. Both parties closing arguments, and the judges providing the jury with instructions for deciding the outcome of the case. Excuse me. At the end of their case, the defendants read excerpts from two documents into the record. The first they read to the jury was part of the JRC's training manual, which detailed the process for obtaining authorization to use more than 10 shocks, and then more than 30 shocks on a student in one day. Namely, it was established a requirement for clinical approval to go beyond these limits. It also mentioned that the recording sheet that staff used to keep track of student behaviors listed the number of shocks that the staff were allowed to use on a particular student. The second excerpt they read to the jury excuse me, was part of a 2008 deposition of Dr. Anthony Joseph, who worked at the JRC. This part of questioning pertained to the contraindication form that had come up numerous times throughout the trial. Dr. Joseph had testified that Dr. Robert Van Hain, one of the defendants in this case, or another clinician, would have witnessed the psychiatrist signing off on the contraindication form. He also said that this process was not done concurrent with or part of the development of a student's treatment plan. Finally, after a brief sidebar discussion with the judge, the defense attorneys were able to admit the JRC's article of incorporation into evidence. With this, the defendants rested. Immediately after this, out of the presence of the jury, the defense attorneys made a motion for a directed verdict, or rather, said that it was renewing, though it is unclear as to when it had made the first attempt, asking Judge Dorch Akara to rule in their favor without allowing the case to go to the jury. David O'Connor, attorney for the JRC founder and former executive director Matthew Israel, and current executive director Dr. Van Hine, as well as the JRC itself, argued that the two individual defendants who he represented did not have Andre as a student or patient, and thus owed him no duty of care. He was in your facility. You were the one who overheaded everything. Guess what? You're liable. He went on to say that neither defendant had been involved in providing Cheryl McCollum's, Andre's mother, with the information about treatment at the JRC in the process of her deciding whether to admit Andre into the program, and thus the informed consent claim against him should fail for the same reason. What is this bullshit? You all approved the materials that went out to Andre's mother when you were pitching your pitch to get Andre in your torture school, okay? You're liable. Just saying. Moving on. In supporting the motion for a directed verdict, Edward Hinchy, attorney for the third individual defendant, Dr. James Riley, pointed out that the plaintiff expert, Dr. Mayor Whaley, had agreed that the use of the restraint board had been reasonable. No, it was not reasonable. Not under any fucking circumstances was that considered reasonable. How is a 4-point board reasonable for someone refusing to remove his coat? The hell are these people smoking? He also said Dr. Riley had not known about any of the GED applications Andre had received while on the restraint board. My God, nobody knows nothing, do they? Benjamin Novotny, counsel for the plaintiff, refuted Mr. O'Connor's arguments and pointed out that Mr. Hinchy was factually wrong on both issues. As he remembered it, Dr. Whaley had, in fact, said that putting Andre on the restraint board had been a terrible idea, and Dr. Riley had testified to witnessing Andre being shocked twice once he was on it. The judge denied the defendant's motion. Thank God. No allergy, Heimlich's phantasmagorical. Moving on, the judge and lawyers went on to discuss the instructions that the former would give to the jury, as well as the questionnaire that the jury would fill out specifying who, if anyone, was liable and for how much. The judge sustained Mr. Hinchy's objection to the way Mr. Novotny had requested the issue of damages to be framed in the jury questionnaire after a short discussion on the matter. The debate over jury instructions was significantly longer. It began with Judge Dorch Akara telling Mr. Novotny that she was unlikely to use the exact language he suggested. Mr. Hinchy followed up on this with several objections on how Mr. Novotny had worded the proposed instructions, saying that he would prefer more neutral language. I bet you would. He asked that, rather than following the plaintiff's version of instructions, the judge rely on the model jury instructions or the language that the defense had proposed. The judge struck out several of Mr. Novotny's proposed instructions in response to these objections. Dr. Hinchy insisted that the jury instructions make it clear that Dr. Riley could not be held responsible for the alleged allegations of informed consent. Of course you would. Nobody's responsible. A kid gets tortured, and it's nobody's fault, right? Have I said I hate people today? I hate people. For his part, Mr. Novotny objected to the language of causation that the defense had included in their proposed instructions, as well as that regarding Andre's absence from the trial. Despite Mr. Hinchy insisting that there was no reason that Andre couldn't have come to testify himself, The judge refused to provide the jury with what she referred to as a missing witness instruction. She also sustained an objection by Mr. Novotny to a part of the defendant's proposed instructions that said that a treatment's failure to effect a cure was not by itself a medical malpractice. What would you call it, Karen? Because there was no cure or expectation thereof at issue in this case. Then why use it? God. There was also discussions over instructions that pointed out Dr. Israel was not himself responsible for the actions of other JRC staff. No, you just oversee them. You're not possibly at fault. God, seriously. In light of his testimony that he was in fact legally responsible for everything that happened at the facility. Your own words, dickbag. Your own words. After some explanation by the defendants, the judge agreed that Dr. Israel could not be held vicariously liable for actions of others and said that this fact would be included in the final versions of the jury instructions. Really? Really? No wonder the bastard got off. The parties debated over the defendant's proposal that the jury's instructions contain language to the effect that it was the case was only about the events of the 25th of October 2002 and not the JRC's treatment program as a whole. It should have been. It should have been. Mr. Novotny argued that the trial was, in fact, about the treatments used at the JRC in general. Thank you. While Judge Dorch Okara agreed to specify the time frame for the events that the jury should be focusing on in their decision, she refused the entirety of the defendant's proposed language, saying, I can't limit the jury to that extent. Lastly, before closing arguments began, the court heard... One moment. Thank you. I'll start that sentence over. Lastly, before closing arguments began, the court heard both sides on whether Mr. O'Connor should be allowed to use some of the judge's own words earlier in the case as part of his own closing. Mr. Novotny argued that the court itself should not be brought in to make his case look bad. The judge agreed, saying she did not want her words to be misused in order to smear the plaintiff. Mr. Hinchey gave the first closing argument on behalf of Dr. Riley. He opened by thanking the jury for their time and attention, saying that the case was very important to Ms. McCollins, but that it was also very important to all the people from JRC who were parties to or had come to observe the trial. Every single one of those torturous bastards to hell. Sorry. This is not for children, did I mention? From there, he immediately framed the case as being about what happened to Andre on the 25th of October 2002 in particular. According to him, even Dr. Whaley, the expert, and I'll put that in quotes, what a dick, didn't agree with the JRC's use of restraints and electric shock on Andre that day. He went on to reiterate what had been said about Andre himself throughout the trial. Specifically, he said that there had been two Andres, one charming and sociable and the other unpredictable and aggressive. You know, for screaming and tensing up while being shocked and wanting to run away from the orderlies when being shocked and, putting the electrodes over his socks so as to not be shocked. That's unpredictable and aggressive. And that this complex nature of Andre, it's not that complex, Karen, I can explain it, had led, among other things, to the boy being hospitalized 3 times by the age of 10 and diagnosed with a pervasive developmental disorder. To illustrate Andre's aggressive nature, Mr. Hinchey reminded the jury of the fact that Andre had been restrained at the JRC for his behavior 20 times before. Because you were shocking him. Oh my God. And also of the JRC's direct care worker, Casey McCauley's testimony on the previous Friday, that Andre had bit her and broken 3 of her fingers because she was shocking him. God, maybe I should have a degree in this. Jeez. Bring some common sense to the freaking medical field. Jesus. The JRC, Mr. Hinchy said, had tried to help Andre become that vision of himself that Dr. Israel talked about during his testimony. The program had afforded him with individualized treatment plan consisting of adversives and rewards to improve his behavior and give him a chance to be more independent. That's freaking disgusting. Stick and carrot. It's ABA all over it, folks. Furthermore, JRC's staff had cared for him. Oh, I love their version of care. Sign me up for that. No, thank you. Cared for him. And in fact, visited him in the hospital after he left. Yes, let's further traumatize him. Every abuser who abuses their kids always sing how much they love them while they're hitting them. It's no different here, folks. They're singing how much they loved and cared for him while they were torturing him. I'm sure that was comforting. Mr. Hinchy concluded this part of his argument by saying that the witnesses for the JRC in the trial, many who have worked with Andre, were the true face of the JRC. If they're the true face of the JRC, God help us all. As for Dr. Riley's part in this, he told the jury that Riley had been on the video footage and thus had been involved in what happened for a mere 20 minutes. When he came in after Andre had received 10 shocks, Dr. Riley gathered information from staff and briefly from Andre and had observed Andre being shocked and admonished for his behavior twice, for tensing up while being shocked. Jesus. He brought in the restraint board, according to Hinchy, because he noticed Andre was stressed out by being physically restrained by staff. Gee, I wonder. I would also be stressed if somebody was physically restraining me while using electrodes to shock the hell out of me. Most of us would see that as perfectly reasonable and not a behavior for which we should be put on a 4-point board and shocked more. Okay. The decision, the attorney said, was one that even Dr. Whaley couldn't agree with. I can. Put me on that stand. I'll take a time machine. I'll explain it to you. Then she went on to describe how Dr. Riley watched Andre as he was put on the board, initially struggling but seeming to calm down after being shocked. It's called trauma, folks. It's much like how a child may quiet down after being hit, but it doesn't mean that it helped the child to be hit. God! Dr. Riley then asked other JRC staff to keep him informed if there were any further issues, and asked another doctor to call him later about Andre's condition. Finally, he wrote a note before leaving, mentioning that there had been 11 GED applications that day, and that the problems Andre was experiencing may be related to his mother's refusal to follow the treatment plan on his last home visit. Are you kidding? You really putting the blame on her for not torturing him at home? Really? God. It was unclear whether she misspoke here, or rather if the 12th GED application that Riley knew of was actually not mentioned in the note. The standard of care for the purposes of the lawsuit, he reminded the jury, was what a reasonably prudent psychologist would do under the circumstances. A reasonably prudent psychologist, in your estimation, would say this was okay? My psychologist wouldn't? God, You want to talk about taking somebody to school? Maybe I should introduce them to my psychologist. The evidence that Dr. Riley had met this standard was, in his words, overwhelming. Overwhelming? Overwhelming. Thank God I didn't live in Massachusetts in 2012. As far... Excuse me, folks. 1 second. I'm sorry. I'm looking forward to summer. Yes, Cyan. Let's try again. As far as the alleged contraindication for the use of the combination of adversives was concerned, Mr. Hinchy said that this was the fault of Dr. Van Heim, who had simply failed to have the psychiatrist initial that part. Thus, it was nothing more than sloppy work. Andre's treatment plan, on the other hand, had included combination adversives. There have been no witnesses in the case who had testified as to how or why they should have been contraindicated for him. His mother put in a professional request for those electrodes to be removed from his arms. Seriously? Dr. Riley characterized what happened after the incident as Andre having a reaction. I'll give you a reaction that necessitated him being restrained for aggressive behaviors. To remind you folks, those aggressive behaviors were muscle tensing up and begging, please stop, no. Those are the aggressive behaviors this lawyer's talking about. And had caused him to become withdrawn at other times. Gee, you think? However, he referred to the testimony of defense expert Carol Ball, who said that Andre had suffered no permanent injury as a result of what happened at the JRC. Oh, that bitch again. Yeah, he suffered permanent damage, folks. He will never be outside of an institution now because of what was done. He's gone from one medication to being institutionalized for the rest of his life. So much for those independent skills they were trying to drill into him by, shocking him. Sorry. And, as the attorney pointed out, have reviewed all the records before coming to a conclusion, in contrast to Dr. Whaley, who had not. Andre's hospitalizations after the incident, he said, were nothing out of the ordinary. These poor kids. And this is why we gotta stop it, folks. They consider this ordinary. And since then, Andre had made progress. Yeah, it's called He's Not in Your Center being tortured anymore. Anybody would make progress. The fact that Mr. Novotny had even pointed out that Andre, with the help of his mother, has made improvements was proof he argued that Andre experienced no lasting harm. My ass. Whew. I did tell you I'd try. Towards the end of the closing argument, the attorney returned to Mrs. McAuley's testimony. Oh, God, here we go. Especially of her description of Andre's being Holt-like when he tensed up. Jesus Christ. We can't have him tensing up, even though that's an involuntary muscle movement for being shocked. She was the facts of this case, he told him. She was the reality of what was going on October the 25th. Yes, she was. She was his torturer. And then he got tortured more. As he framed it, the choice of how she and others at the JRC could have responded to Andre's behaviors was between medication and a behavioral program that included versives. Actually, there's other options. It's called positive behavioral reinforcement, and it does not include being tortured, such as having to earn the right for food or go to the bathroom to earn the right to not be tortured on a 4-point board. I have heard it works miracles. Only options, my ass. And folks, I'm very familiar with positive behavioral reinforcement. I have worked in this field as an advocacy specialist. I have met with these individuals who have been through that program. It worked wonderfully. God, I hate people. He asked the jury to consider the complexity of the issues, as it is difficult to have a child like Andre and difficult to design treatment. Oh my God, yes, let's victim blame. That's freaking perfect. He ended by reminding the jury that the reasonableness was standard to be used in determining liability. Reasonableness. I'm going to show you reasonable. And Dr. Riley had, in fact, been reasonable in making the treatment decisions and dealing with Andre. If that is reasonable, I hate Missouri. I hate Missouri. But if that's reasonable, I'll take Missouri over Canton, Massachusetts any day. I thought we were supposed to be backwards. First impressions can be powerful, but we need to be patient, began Mr. O'Connor. Patient. In his closing argument, the evidence that the plaintiffs had presented to the jury as part of their case had, he said, been presented out of context. Really? Really? Tell me one. Give me one person that using adversives actually helped someone improve. One. And I don't mean improved in the short term JRC for your little public PR videos. I mean long term positive changes due to adversives. As the great Cat Williams say, oh, don't worry, I'll wait. For instance, he brought up the piece of video footage that Mr. Novotny had shown in his opening statement, in which Andre was shown screaming while restrained. You used him being screamed while being shocked and restrained as your evidence that he deserved to be shocked and restrained? You're not human. You are not human. In that part of the footage, said the lawyer, Andre wasn't actually screaming in response to being shocked, but rather in response to the noises in the area, such as GEDs being tested elsewhere or the cell phones going off. Really? Really? I hardly see him saying, no, please, help me. And you're going to tell me it's due to a cell phone going off. I call major bullshit. The JRC, he reminded the jury, had a zero rejection policy, and its student population, including Andre, were very behaviorally and cognitively challenged. So shaka, let's torture him into good behavior. That always works. Before using adversives on Andre, they had monitored him for a year, and his behavior hadn't changed. The antipsychotic that he was on, Respirado, which Mr. O'Connor reminded the jury was one Dr. Whaley had used in his treatment, implying this had informed the expert's attorney. Excuse me. Implying that this had informed the expert's testimony, had been ineffective in addressing this behavior. That's in spite of numerous papers and testimony that he was improving under that medicine from the other centers he was in. God, I hate this guy. Just ignore everything you heard towards the plaintiff and just agree with me that torturing people is right and helps. I'm going to quote a Metallica song to you right now, folks. Keep him tied, it makes him well. He's getting better, can't you tell? From Sanitarium. Listen to it sometime. Hadn't been effective in addressing this behavior, which the attorney described as aggressive, health dangerous, verbally inappropriate, and socially disruptive. Then he contracted Dr. Willie's testimony with that of Dr. Lloyd Price. Oh, yes, Mr. Price. And the defendant's other expert witness, Dr. Price, who doesn't think Andre has autism because he can communicate. Oh, he's a stellar witness. He said, looked at all the available evidence, whereas Dr. Whaley had not. Dr. Whaley had, in fact, fast-forwarded through more than half the video footage and only gone back to rewatch the rest of it and correct his testimony after being called on it. Maybe it was difficult for him to watch a kid get tortured. Thought. Thus, the latter's opinion about the JRC's actions constituted a gross neglect of duty that had been based on incomplete information. Yes. Who's delinquent in their duty before this court? Mr. O'Connor asked the jury. He further discussed the nature of the population that the JRC works with. Victim blaming the entire student body that you torture. Oh, that's classic. Asking the jury to give some deference to these clinicians who worked at the program. Hell no, I won't. He admitted that events shown on the video were unsettling, but he insisted that the methods the staff had used that day were necessary in dealing with the type of people JRC takes on. Oh my God. So it's okay to torture people as long as they have a disability. That's what that says. As long as a person is mentally ill or they have a disability, it's completely okay to torture them in the name of they're good. That's what that says. Don't let anyone tell you different. Well, let's hear what this torture apologist has to say. People that are not in the general public very often, and for very good reason. These people, he said, were very different from the patients that Dr. Whaley worked with in his practice. And how would you know? You ever met any of them? With regards to the treatment of JRC provided to this population, he admitted that do no harm was a core principle of the medical profession. Thank you! But asserted this had to be a downs against no pain, no gain. This is sick. Dr. Whaley... Excuse me. Dr. Whaley, Mr. O'Connor said, would have had the JRC ship Andre off to a psychiatric facility. As it was, Andre had been heavily medicated, chemically restrained, in fact, at the Children's Hospital, Boston. Yeah, he was chemically restrained. It's called receiving hospital treatment, you dumbass. They had to fix what you all broke. Once he had transferred there. In fact, Mr. O'Connor said his catatonia may have been a result of the medications or the psychosis he had been experiencing around that time. Victim blaming shit. Rather than fear. As far as Andre's fear was concerned, the attorney informed the jury that Andre had been just as afraid in the hospital as he had at the JRC. Considering what he just went through, he's going to be afraid of the planet, moron. That kind of trauma doesn't just go away. Thrashing around in his bed the same way he had while on the restraint board on the day of the incident. Yeah, he was reliving it, moron. PTSD is a thing. He characterized Andre's condition in a hospital as up, down, back, and forth, and said that this was the usual state of affairs with him, implying that it could not be attributed to what happened at the JRC. Actually, that tells me that's exactly what you can attribute it to. Exactly what you can attribute it to. At times, according to hospital records, Andre asked his mother and had talked about things he enjoyed, such as a band, Destiny's Child, but by the time he had left the hospital, he had returned to baseline. It was unclear, Mr. O'Connor said, as to what damage was actually caused by the incident at the JRC. Well, it's known now. It's been well over a decade. And the damage was permanent and long-lasting, folks. He will never be independent, ever. These people took that from him. He went from being on a fast track to going into a residential program to being in an institution for the rest of his life. It's been damn near 20 years. Not long lasting, my ass. Focusing on the roles of individual clients, he said that Dr. Israel nor Dr. Van Hine had been Andre's doctor. No, they only overseed his doctor, and had not participated in drafting his court-approved treatment plan. Furthermore, they had no part in obtaining or recognizing the withdrawal of Mrs. McCullen's consent for the use of verses in treating him. As far as the contraindication form mentioned earlier was concerned, it was secretarial, and Dr. Hine had necessarily known what was on it. You run the school, which means whatever goes on in that school is your responsibility, i.e., you are liable. Not to mention, you're the insane fuck that created that machine and the 4-point board. Take several seats, Mr. O'Connor. I'll try to not make this another hour, folks. Dr. Van Hine, Mr. O'Connor reminded the jury, had checked on Andre after hearing screaming coming from the classroom, even though Andre was not his patient, and he had no obligation to get involved. My ass. At the time, he simply observed what was going on. Both then and when he later returned, according to his attorney, he wasn't callous about any of what happened, and in fact asked Andre if he was hungry or wanted water. The only reason that the attempts to take Andre off restraint board while Dr. Van Hine was there, he said, was because Andre's own reaction to this, namely his struggling. He wants to get the hell out of that room where people are torturing him. Seriously? I'd be running for the hills too. He framed Mr. Novotny's statement earlier in the case that by the time Dr. Van Hine got involved, the harm was done, in such a way as to suggest that Dr. Van Hine had not actually caused any harm of the harm himself. You're still liable, jackass. In fact, he pointed out that Dr. Van Hine removed the tense-ups from the list of target behaviors for which Andre was allowed to be shocked that day, even though the shocks were apparently succeeding in calming Andre. Calming Andre? You were shocking him into conformity. How the hell is this okay? How the hell do you think that's what he needs to calm down? The fuck is wrong with you people? It was at this point that Dr. Van Hine went to get help from Dr. Israel, who upon observing the situation realized that the treatment wasn't working and prohibited staff from shocking Andre anymore that day. Was it perfect, the attorney asked? That's not the issue. To think that could have been used on me. Could have been used on a lot of us. On the subject of what happened after the incident, Mr. O'Connor said that as far as his clients had known, Andre was getting medical attention from the nurses on staff. In fact, Andre was checked on by multiple people, who at least as of the day of the incident had told Dr. Israel and Dr. Van Hine that Andre was not dehydrated. That makes this 1,000 times worse. In any case, the treatment Andre received at the hospital had not all been that different from what he received at the JRC over the weekend. Okay, let me get this straight. Him being treated for the injuries sustained and the dehydration at the hospital was no different than you shocking him over 30 times? Really? Really? Because I can see a huge difference. You let me know in the comment section if you also notice a huge difference between these two things. Maybe it's just me. I don't know. After all, I'm just a flawed autistic who deserves, according to the JRC, to be shocked like this in order to keep me calm. God help me. In any case, the treatment Andre received at the hospital had not been all that different from that which he received at the JRC over the weekend. Furthermore, Dr. Israel was not really a clinician, and medical issues were not part of the role that he or Dr. Van Hine served. Then, how the hell was this approved? God, they just want to pass the buck to everybody, don't they? He asked the jury to instead focus on the mission of the JRC, which is namely getting kids off chemical restraint. The mission of the JRC is to torture kids. That's it. I don't care what they say. That's what they do. The options, folks, are not just torture or medicine. Don't drink the Kool-Aid. Just saying. Like Mr. Hinchy, Mr. O'Connor returned to the subject of Miss McCauley's towards the end of his argument, asking the jury to think about her, I'd rather not, and other members of staff putting their hands on Andre that day, even though he had been violent to them in the past. Because they had been violent to him in the past. Dude, have you never heard of self-defense? He assured the jury that he did not say this in order to impugn Andre. Sure you didn't. You just want to blame him. But instead to remind them that the general public doesn't have to deal with challenges that behavior like his poses in the way that the JRC staff does. That's because they don't abuse him. Thoughts. Common sense, mother. Do you have any? He characterized Dr. Israel in particular as an idealist, seeking to treat society's most troubled people, torturing society's most troubled people. Miss McCollins, he said, had turned Andre over to Dr. Israel and the JRC specifically because she didn't understand and felt uncomfortable with Andre's behavior. He reminded the jury to look at the evidence in context, namely in the context of a facility staffed by the people who did not look away and ignore people with the most severe behavioral problems, but instead decided to address their needs when no one else would, by shocking them. By shocking them, depriving them of food, and that they can only earn food as a reward, earn bathroom breaks as a reward. Is this dude fucking kidding me? Thank God I didn't choose to become a lawyer. If I had been a part of this case, oh my God. In the beginning, in his closing, Mr. Novotny, oh thank God, began by describing what happened on the 25th of October 2002. Namely, a child with developmental disabilities had been restrained and repeatedly shocked for being scared and tensing up. Where is the reason in that? He asked the jury. Thank you! That day he told them Andre was a harm, a danger to no one. And yet the staff had shocked him, and even laughed as they did so. He asked the jury what kind of treatment these shocks were anyways, when none of them succeeded in addressing Andre's behavior. He went on to describe how, after the incident, Andre had been shacked, tied up in restraints for days afterwards, and the JRC could have instead provided him with actual treatment. He shifted to a more general attack on the JRC and its methods. Dr. Israel, he said, has been operating on the fringe of medical treatment for decades. Thank you. Beginning with his failed attempts at establishing a utopian community. As for electric skin shock, Novotny reminded the jury that it was used nowhere else outside of the JRC because it was well known that it doesn't work, just as it had not worked for Andre. Ask yourself, he said, is this reasonable to do to anyone, much less a child with special needs? Thank you! We don't like the term special needs, but here's your mulligan, Mr. Novotny. He reiterated that Andre, in particular, had been shocked for screaming and for being afraid, and asked the jury who wouldn't scream under such circumstances. Thank you, finally some sense. Responding to Mr. O'Connor's request that the jury give deference to JRC's clinicians, he said, "We saw what happens when they're given deference. This is not a time for deference." Thank you. Get him, Mr. Novotny. Get him. Mr. Novotny shifted focus onto Andre, saying that the plaintiff could not help his behavior and that he deserves to be treated humanely with dignity and respect. But he wasn't. Andre wasn't the violent monster that defense made him out to be, his attorney argued. He was a child. To illustrate this, Mr. Novotny referenced a sentence completion exercise that Andre had done at one point, which included statements such as, "Others think I look happy," and "mothers understand their kids." Additionally, he reminded the jury of the testimony earlier in the case that established that Andre had been doing well at the program he had attended before JRC, and the medications had been working for him. Thank you. Where the JRC was concerned, he said Andre's mother was sold on something very different than what she got. The promotional video that JRC had used to convince her to send Andre to the program did not show students being shocked. Furthermore, she had not been warned of the side effects of the shocks, namely abrasions, PTSD, catatonia, and regression, all of which Andre had exhibited after the incident on the 25th of October 2002, and those are still going on to this day, folks. Instead, the JRC used its anti-medication message to sell her on an aversive-based program, and Mr. Novotny told the jury it was the same message to sell that program to them in the courtroom. He referred to parts of the record that said that Andre had been doing well at the JRC without the use of electric shock. In spite of this, he said Dr. Riley had planned to develop a treatment plan that included the use of aversives from the very beginning. The resulting plan was a boilerplate, one size fits all, and as Dr. Riley himself had said, a fixed standard form. In particular, Mr. Novotny pointed out it did not take into consideration Andre's history of having been sexually abused, which was mentioned in his records, or includes measures to make sure that he would not be re-traumatized by the use of aversives. In Dr. Riley's affidavit to the probate court, which it had relied on in approving the treatment plan, there had been no mention of the good behavior that Andre had been exhibiting around that time. On the morning of the incident, Andre, according to Mr. Novotny, had not been oppositional when he came into the classroom. Instead, he sat there, docile. He was minding his own business. The attorney again asked where the reason was and what the JRC did to Andre, this time in regards to their shocking and restraining him when he didn't want to take off his coat. Later, when Andre was on the restraint board, he was quiet, and Mr. Novotny pointed out that at the time, the staff could have talked to him and figured out what was going on, but didn't. With regards to the three individual defendants in the case, he brought up how Dr. Riley left the JRC that afternoon, while Andre was still in restraints not to visit another patient, but to go do paperwork instead. The fact that Dr. Riley was there for only 20 minutes, as Mr. Hinchy had said, was exactly the problem, he argued. Furthermore, he suggested that Dr. Israel obviously didn't consider Andre to be high enough priority and that he stayed uninvolved for most of the day. The absentee executive director, according to earlier testimony, in fact knew nothing about Andre. When Mr. Novotny then pointed out that Dr. Israel was not in the courtroom for closing arguments, suggested that he must have thought that the case was not a high enough priority either, Mr. O'Connor objected, and the judge ordered the jury to disregard the comment. As far as Dr. Van Hine was concerned, Mr. Novotny insisted that it had not been enough for him to say that Andre was not his patient, and that he should have realized that something unusual was going on the first time he entered the room to see what was happening. To do something would have been reasonable. Doing nothing isn't. Thank you. All in all, Andre McCollins himself had given 3 minutes of the clinician time during the entirety of the incident. This was, according to Novotny, an error of judgment and an error in logic. Thank you. He went on to say that at the end of the day, Andre was gone. The JRC talked to Andre then, and it had helped him. But by that point, he had already been damaged. What followed, in Mr. Novotny's words, was that they warehoused him. They drugged him up, restrained him, and left him. Where is the reason in that? The only reason that Andre had gotten out of the JRC and had been transferred to a hospital was because his mother, who was horrified by the facility's treatment of her son, had come to take him there. This testament, Mr. Novotny said, was what rendered Andre catatonic, putting him into a constant state of fear. Thank you. O'Connor put Dr. Whaley on trial, Mr. Novotny said, encountering the attacks on the expert testimony. Well, he's not. Dr. Whaley hadn't needed to see the whole video up front to know nothing on that video was okay, he argued, or to see that the JRC staff just kept hammering and hammering and hammering on poor Andre. He also pointed out the problems, as he saw them, with the defense's experts. Dr. Ball worked with a different population than that of the JRC and was biased by virtue of having worked with JRC in the past. In addition, the most that she had been able to say in support of Dr. Wiley was that he stood around and observed what was happening. Meanwhile, Dr. Price had attempted to diagnose Andre only after having looked at his medical records and had said he could tell that Andre hadn't been scared while being shocked and restrained simply by watching the video. God, he's an idiot. Even Dr. Van Hine, Mr. Novotny pointed out, had said there was no way to tell if Andre had been scared at the time or not. Novotny gave his own take on Andre's reaction, saying, "If that's not scared, I guess I don't know what is." Thank you! Thank you! You can tell a lot about a society, Mr. Novotny said, wrapping up his closing argument, by how it treats its most vulnerable people. He used this as a springboard to ask the jury to send a message to the world, and specifically the defendants, about what they thought about how Andre was treated at the JRC. After walking them through the claims that they had to decide on, he ended by telling them that Andre couldn't speak for himself, and asking them to speak for him by finding the defendants liable for medical malpractice. Mr. O'Connor and Mr. Hinchy objected to Mr. Novotny's closing statement, the former on the basis that the informed consent issue should not have ever been raised, and the latter to how Mr. Novotny had essentially tried to make this case a referendum on the JRC's program as a whole. It should be. On the former issue, Mr. O'Connor asserted that the issue had been raised earlier in the case than it was, and Dr. Israel had no duty to the McCollins family in this regard. No, he was simply a near school. However, the judge allowed the claim to remain part of the case, as both Dr. Israel and Dr. Van Hine. A discussion on Mr. Hinchy's objection was conducted at sidebar and resulted in the judge telling the jury that the issue at hand was not the use of electric shock in general, but the treatment provided to Andre on the 25th of October, 2002. Who bought you? Probably Autism Speaks. After a break during the judge drafted the final set of jury instructions, court resumed so that she could deliver them. She first appointed one of the jurors to be the jury foreman. She explained to him that he could ask her questions on the behalf of the jury over the course of deliberations. In instructing the jury, she informed them that they were the sole and exclusive judge of facts, and that their role was to apply the law to these facts exactly as she explained it to them, whether they agreed with it or not. Their decision, she said, could only be based on facts, not on personal biases or sympathy. They could not decide the weight and the value of the evidence, both direct and circumstantial, based on their common sense and life experience. They did not have to accept any of it, even that provided by the expert witnesses, as true or credible. In evaluating the evidence, they could consider witnesses' inconsistent statements, bias, motive in testifying, appearance and demeanor, among other factors. However, statements and rulings by the judge, questions by attorneys, opening and closing arguments were not evidence that they were allowed to use in reaching a decision. She explained in detail that the claims against the defendants, namely medical negligence and the lack of informed consent, and told the jury that they must decide whether it was more probable than not the allegations against each defendant were true. Finally, she listed the types of damage that they could award the plaintiff if they found the defendants liable, and described the way in which they were able to calculate the amount. As the day nearly at an end, by the time the judge finished giving the instructions, the jury had very little time to deliberate. Before leaving for the day, they asked the JRC as an institution was a defendant or not, as prior documents had stated that it was. The judge said she would answer this question the following day. I was not able to attend court the next day, so I don't know what the judge's decision on the issue was. However, based on court documents and subsequent news reports, it's likely that the JRC itself was in fact a defendant. After several hours of jury deliberations the next day, the parties agreed to settle for an undisclosed amount of money, and the judge approved the settlement. Even since their clients signed into this agreement, the defense attorneys have insisted that the JRC and the 3 individual defendants were not liable and have defended Andre's treatment as reasonable. They went so far as to say they were glad that the tape was shown in court, allowing the jury to see that Andre was receiving proper treatment at the JRC. Though Ms. McCollins is forbidden by the terms of the settlement to discuss the amount Andre received in damages, she remains vocal in her opposition to the JRC, and has said that she intends to continue to fight against its use of adversives through other forms of advocacy. And folks, that covers all of it here. We're going to be going over some more information about the Judge Rotenberg Center as well, but I did think it was very important that you know exactly what happened back in 2012. It was about around the same time when the United Nations declared what was going on at the JRC as torture. And still the United States has not done a ban. We actually, with the UN, we had this worldwide agreement that only 2 countries in the world haven't signed on to yet in regards to the ethical treatment of people with disabilities and against the torture of people with disabilities. Out of all the countries that have signed in the world, there are still 2 remaining countries that have not yet signed that treaty. That would be the United States and Iran. True facts. We will be going over that as well as the letter that started things rolling with the FDA that we were working towards that ban. Now, before we close out, the reason why we're going over this, when we supposedly got the ban back in March of 2020, why do I feel the need to drill into this now? I'll show you. This is what got me back into this fight. This came out in April. A decades-long fight over electric shock treatment led to an FDA ban, but the fight is far from over. Sorry, folks. There it goes. This thing's getting weird. What they're doing is just taking people that have issues and just building more, said Rico Torres, who was first shocked at 8 years old. So, the electroshock treatment led to the FDA ban, but it is still being used at places at the Judge Rotenberg Center. I will actually go ahead and go over this with you tomorrow. Now, that's all I got for this afternoon. My screen's freezing up a little bit, but we will go over this article. This is what got me on a spree of doing these videos about the JRC. Now, in the meantime, folks, we don't get very many views on this channel. The few views that we do get do tend to get removed from time to time. So please don't forget to hit that like button. Hit subscribe. Don't forget to hit the comments. I will be back tomorrow with this article from NBC News that spread through the autism world like fire. Broke out a lot of hearts on April the 31st, and why this fight has been dragged back into the forefront. And I do appreciate your time today. Now, before we get out of here, at 4:30 Central Standard Time, 5:30 Eastern Standard Time, 10:30 UK, we are going live on this channel with open chat, where we will talk about whatever you want to talk about. We can talk about this and what's going on with the JRC. We can talk about ABA and why the autistic community is against it. We can talk about JD versus AH. We can talk about if there was some rock that you found interesting today. It's open chat, so you all decide. Please join us. We are going to have the usual suspects, Phantasmagorical, hopefully Tammy Talks, and your boy Gary. Hopefully Keely as well. We'll just have to see. We'll play it by ear. I do hope to see you all there, and I appreciate your time this afternoon. I hope you all have a good one. I will see you in a few hours.